All right, everybody, welcome to May 2026 Lunch with Liz, where you just started our fifth year of doing it. We just had our fourth anniversary, so this is our fifth year of doing these monthly sessions where people can come on, learn about a topic, and be able to ask questions, which is why when I started it, I didn't want to do a podcast or a blog or something like that. I wanted to actually, talk to people and have them be able to talk to me so that hopefully by the end, you've got whatever questions you had when you decided to join me today answered. If you don't know, my name is Liz Moneymaker. I'm your hostess this afternoon for the next, give or take 45 minutes to an hour. The way it's going to work today is I do have some slides. You should see those up on your screen. I do that because I know some people are visual learners and some people are that learn more from hearing. So I like to just have a couple different mediums available. It is being recorded, so if you have to step away for some reason, just know that it'll be posted on our socials and on our webpage next week. If you know someone who should listen to this information, you can share that with them next week as well. So that just because they weren't here live doesn't mean they can't get the information. There are a couple different ways you can ask questions. You can come off mute and ask at any time. There's a chat function, which is what a lot of people use. I will look at it periodically and then come back to it at the end. And at the end, I'll open it up just for general questions about the topic. I do, because this is being recorded for this specific topic, I keep the questions limited to what we're talking about today, which is what is probate and how to avoid it. Some people with their questions get a little too specific about their own personal issues. For that, I recommend scheduling an appointment if you want to come in and talk. I do offer complimentary consultations for estate planning and probate. So that's available to you as well. The main thing I want to get across before we get started here is you guys have set aside time to come here today. For whatever reason, you have something you want to know, something somebody told you want to verify. So I just don't want you to leave today without having that question answered. If I didn't get to it, it might have been something I should have gotten to and I just overlooked it in my notes. So don't feel shy at all about saying, hey, Liz, what about X, Y, or Z? All right, let me move on to the next slide here. All right. What is Florida probate? I try to make it a little sexy, like probate exposed, but there's really no way to make probate sexy. I apologize about that. So this is going to be a little bit mundane. But this initial slide is really important. I'm going to spend some time talking because I need you to understand this concept before anything else that I talk about today is going to make sense. Think about, for example, what you own as an individual. You might have bank accounts, you might have cars, you might have boats, RVs, jet skis. You might have investment accounts that are stocks or mutual funds, bonds. You could have a condo or a ranch in Texas. You could own a timeshare. You could have savings bonds. You could have a safe deposit box. You could own crypto. All the different things that you own. Well, when you die, there has to be a way to legally transfer ownership of your property to somebody else. That is what probate is. The key, though, and here's the big asterisk star, star, star key to take away, is probate's not the only way to do that. There are a lot of other ways that transfers happen upon death that aren't probated, that aren't the probate process. We're going to talk about all those, but just to give you an idea, it's joint ownership of accounts and property. It's beneficiaries on accounts, transfers on death, pay on death. It's using trusts. It's using transfer on death deeds for real estate. So there's a lot of different ways that we transfer property at death. Probate is what happens when we haven't used any of these other mechanisms. If there's no other way and I've died with one of these things that I've just said, the bank account, the house, the condo, the property, if that's titled just in my name, and I haven't come up with some other way for it to pass to somebody else when I die, that's when probate comes in. The key is if you're relying on a will to transfer ownership of your property, whether that's a condo, a house, a bank account, a brokerage account, whatever, if you're relying on the will to do that, you're guaranteeing the probate process. That's a big myth that I've been battling since I started to practice law, and that people think, well, I have a will, I'm going to avoid probate. A will does not avoid probate. So that's the first thing to think about as we're getting into today is understanding that there are a lot of different ways to transfer legal ownership of property when we die. And by property, I'm talking about more than just real estate property. I'm talking about all the stuff that we own. And probate is just one of them. And before I talk to you about how to avoid probate, we are going to talk about what it is. So essentially, it does one of two things. It either validates your will and then follows those instructions, or if you don't have a will when you die and you have assets that need to go to somebody else, it determines who your heirs are, who are the legal people that are entitled to receive your property. So remember, under probate, there's two things. One is if you have a will, we're going to determine the validity of the will. And number two, if you don't have a will, we're going to determine under Florida law who gets your stuff. This is where it's important for me to point out that a lot of people want to go online and do-it-yourself wills, or Rocket Law, or Trust and Will, or Susie Orman, or something like that. And because they think it's easy and what they're doing is easy. Well, one thing that does is they don't come talk to me or somebody like me to explain how you probably don't want the will to control your assets anyway, number one. But number two, frankly, you don't really know what you don't know. And by the time we've figured out in the probate process that the will was done incorrectly or is invalid, it's too late. And if you have somebody like me drafting the will and there's something wrong with it, then what? I've got malpractice insurance, right? So there's something for your heirs to go after. Whereas if you've gone on Trust and Will and downloaded something and it's not right, there's no recourse for your heirs. So that's one of the main reasons I don't suggest people do-it-yourself wills or any of those downloadable forms on the internet. So we're going to talk in the next slide about how Florida determines who your heirs are if you don't have a will. So I don't want to belabor that point, but that is one of the things that probate does if you don't have a will. Then, whether you had a will or you didn't have a will, what probate does is it lets your executor, your personal representative, in Florida, we call it a personal representative, but probably all your life you've heard it named executor. They're the same thing. So if I use both terms, just know I'm using them interchangeably. The person that's appointed to do this job is the person that has to figure out where all your assets are, consolidate those, figure out who your creditors are, whether those debts are valid, see if there are taxes to pay. So they pay all of your bills essentially, and then whatever's left they can distribute to your beneficiaries, whoever those are. That's in a nutshell what probate is. In Florida, in where we are here in the Tampa Bay region, standard probate takes anywhere between 9 to 12 months. Sometimes they can be faster, but generally I always tell my clients to estimate that, and it'll cost anywhere from $3,500 to $10,000. Which, again, circling back to the do-it-yourself thing, is if you save money on the one hand, you're going to pay it on the other hand if you haven't put together a good plan that potentially could avoid this probate expense. All right. This is busy, 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 and I don't have convulsions or anything looking at it. But what this is what Florida calls its intestate succession flowchart, and it's a simplified version. What intestate means is you died without a will. So this is how Florida law determines who gets your stuff if you didn't have a will in place and you didn't have any other way in place to transfer your assets. So you didn't have pay on death, transfer on death, beneficiaries, or something like that. So what Florida asks first is, does the person have a spouse? If the answer is yes, we ask, did they have kids? Yes, we need to know, are the kids from that relationship with the current spouse, or are they with from a different relationship? If they are with the current spouse, the spouse gets 100% of everything. If you had children from another relationship and you didn't have a will, your current spouse gets 50% and your children from the other relationship gets 50%. That is a huge thing that really makes it difficult for some clients that didn't have a will in place, because they just assumed that, well, I'm married to him, I'm going to get everything, but that's not the case if the kids aren't from that relationship. If they're not married, then you probably have seen this in other blogs if you've studied up on probate at all because you're curious, but it kind of goes what you would think. Do they have kids? Then it would go to kids. If they don't have kids, it would go to parents. If they don't have parents, it would go to siblings. And if they don't have siblings, it stretches out from there. If they can't find anybody at all related, it'll go into unclaimed funds for a period of years. And eventually it would go to the state of Florida if no one ever claimed it. That rarely happens, at least in my practice. I've never had it happen. I've always been able to find somebody. But that's probably not your wish, which is another reason why having a plan in place is important. Otherwise, somebody you've never met could be the one getting the stuff that you've worked really hard for. Just going to check the chat just to make sure, and I don't see anything there. So no questions yet that I can see. All right, next slide. I'm killing you with the slides today, the charts. This one is just talking about the probate process in Florida. And a lot of my clients get frustrated when I tell them, how long it takes. And this kind of gives you an idea of why it takes the time that it takes. And it starts up here on the top left where somebody dies, right? And then we have to figure out if they have a will. We have to deposit that will, or essentially file that will with the court. And then we've got to figure out what assets did they have, that kind of thing. And then we can file for probate. And we can ask the judge to appoint someone as personal representative. The judge does that. The judge typically in this area wants that person to post a bond. Once that person is appointed the personal representative, then they have authority to go to the banks and the brokerage accounts and potentially hire a realtor to sell property. And during that time that they're doing that, if you see that red arrow there, there's what we call a 90-day creditor period, which means we really can't do anything under that 90 days. So we have a built-in delay of 3 months that we're really not doing anything. Due to the court requiring us to give potential creditors time to make claims on somebody's property. This is what's get frustrating for a lot of clients, because they're like, well, Liz, what are you guys doing? I haven't heard from you. I'm like, remember, I told you we have this 90-day waiting period while we're waiting for claims to come in. Once the 90-day period is over, we get busy again. We're paying the claims if we have them. We are figuring out what money is left, if any taxes are owed. And then whatever's left, we eventually pay that out to the beneficiaries and close the probate. So that, all those green boxes and arrows kind of give you an idea of why it does take that 9 to 12 months generally for a formal probate. What I've talked about in the last couple slides is the formal probate. Well, sometimes we can do a shorter version of probate called a summary probate. Summary administration is faster, cheaper, and less involved than formal administration. There are some pretty stiff criteria to qualify for a summary administration, though. Right now, in May of 26, you can't have more than $75,000 in non-exempt assets, or the person has to have been dead for 2 years. We're lucky in that 75,000 limit is going to, I believe it's going to double in July of this year. So we'll be able to do potentially more of these smaller probates, less expensive, um, less in duration, typically probates with that change. Um, the key about the summaries is if there's a doubt whether it qualifies for summary, I tell my clients we should just go ahead and do formal because we don't want to spend the time and the money going down the summary route and then halfway across the river we have to paddle backwards and do the formal. So there's a little more due diligence involved in this one to ensure that this is really the route that we can go. If they've been dead for longer than 2 years, it's usually a no-brainer. But if they had recently passed and we're just not sure about the assets or potential debtors, then we really are better off going the formal route. All right. Well, Liz, dang it. Probate sounds horrible. How do we avoid it? Which is really why you're here, right? Is like, okay, how do we avoid this thing that I've heard about, which sounds horrible, probate? So I'm going to talk to you about some things that you can do. Things that you can do without me. But I would advise that you get a consultation with an estate planning attorney so that you can really see what's going to be the best plan for you. When I'm counseling my clients, my philosophy always is what is the least complicated, most cost-effective way of accomplishing the goal. And if we can figure that out in the thing that just makes the most sense, which is the basic will with doing some of these tools I'm going to talk to you about now, we do that. But sometimes people come in, they think they're not complicated, but they really are. And some things that make estate planning complicated, and if you fit into any of these categories, I highly recommend that you talk to someone before you do a do-it-yourself plan or no plan at all. But if you have minor children, if you have special needs beneficiaries, whether they're children or grandchildren or other beneficiaries who have special needs, and by special needs, I'm talking about potentially people with Down syndrome, autism, other physical disabilities as well, and they're relying on government benefits, or they potentially could rely on government benefits. We need to put special language in the documentation for them. Some other more complex planning is people who have blended families. So two people get married and they each have kids from other relationships. That is a complication you need to talk to somebody about. A non-US citizen spouse is a huge complication that needs to be addressed. Could cost you a lot of money or cost the spouse a lot of money if certain things aren't included in the estate plan. If you have property in multiple states is a complexity. And of course, if you're a business owner, that also is a complexity we'd want to look at. But all that aside, I'm going to talk to you now about some of the tools that I help my clients implement to avoid probate. One thing is joint ownership. Now, if you're married, a lot of people have joint accounts. They have joint checking, joint savings. They own their home jointly. They potentially have joint investment portfolio. When one of the spouses dies, then that property automatically passes to their spouse because they are joint owners. Some of my clients want to put children or grandchildren or a niece and nephew on property or on an account because they think that would make it easier in the long run. I always tell you to be careful about this for a couple of different reasons. For one, when you're talking about real estate and putting someone's name on a deed, first problem is can't be undone without their consent, right? So now this person is a half owner in a property, right? And what if you have a falling out? What if they, do something that you don't like? You can't undo what you did. When it comes to all the property, if that person that you've put as a joint owner gets sued or declares bankruptcy, now your assets are at risk because you've made them a co-owner of yours. So I would just say, before you ever put someone on a deed, put someone on a bank account, make sure you've talked to an attorney and a CPA regarding the tax issues of gifting like that before you do it. Again, with married folks, typically there's not an issue, but if you are putting just somebody else on property, you definitely want to talk to somebody about that before you go forward with it. Not my primary way of avoiding probate. Next is pay on death designations. You might hear this referred to as a POD. This is the designation we use on bank accounts. So think checking and savings, money market. Anything that's a cash account would have a pay on death designation. And then same thing, transfer on death designations. There would be anything in positions like mutual funds, stocks, investment portfolios, a CD. Think of things that you wouldn't have a demand for payment right away. They might need to mature, or you might just want to transfer ownership of the property rather than actually liquidating it. Doesn't matter if it's called pay on death or transfer on death. What it is, in all intents and purposes, is a beneficiary. So, beneficiary on a checking, savings, money market, CD, investment account. It's a way to transfer that asset at your death, avoiding probate. The thing to remember about this, and it can be a sticking point with some of my clients about getting this to make sense. But if you've done this, and you also have a will that says everything goes to so and so, let's say your pay on death and transfer on death, everything goes to Mike, and in your will, everything goes to Sarah, the transfer on death and the pay on death are what's going to be followed. It's not going to be the will. So that's just an important thing to think about. Beneficiary designations, things like your IRA, 401k, other retirement accounts, annuities, life insurance policies, all of those have beneficiary designations. And I don't want you to get all tied up in the nomenclature here, whether it's a pay on death, a transfer on death, a beneficiary designation. It's all the same thing, right? It's essentially putting somebody else to get that property when you die. And more often than not, I can't even think of a time where there's not. There's a way to put a secondary or a backup beneficiary as well, whether it's a POD, a TOD, or a beneficiary designation. This is some of the best tools to use to avoid probate on some of our main assets, right? Our checking, our savings, our CDs, our investment accounts, and our retirement accounts. Next, we're going to talk about an enhanced life estate deed. Sometimes you've heard this in Florida referred to as a lady bird deed. Not all states have these, actually most do not. So we're lucky in Florida to have this tool. It is a way, essentially, to put a beneficiary on your real estate. So whether it's your homestead or investment property, we can do a new deed that says, hey, I own this property, and I own it for my lifetime. I can do whatever the heck I want to with it. I can sell it, I can refinance it, whatever I want. But upon my death, it passes to so-and-so. Great way to avoid probate in some scenarios. It's not great if you have a lot of beneficiaries. It's not great if you want contingent planning. So in other words, in the deed, I can't say that my house goes to Margaret, but if she's not alive, it goes to Samantha. There's no way to do that in the deed. So there are some limitations. Additionally, if the person that you've left the house to on the deed dies, we have to update the deed. Otherwise, there's going to be a probate. So it's not a fix it and forget it tool, but it is something good I have in my toolbox to help someone potentially avoid probate. Now, compare that to a living trust. I like to think of a trust like a bucket. You're going to see that reference in a couple slides when we talk about some scenarios. But when you think Liz owns something, Liz owns a condo, Liz owns a couple bank accounts, an investment account, right? So if I create Liz's bucket, and that's Liz's trust, right? So Liz's bucket, and I deed my condo into the bucket, and I retitle my investments and my banking accounts into the bucket. Now, when I die, my bucket doesn't, because buckets don't die. Buckets live forever. This is a way that I can avoid probate, because everything now is owned by this, pretend entity, this trust bucket. And I have put instructions on the outside of the bucket that says what I want to happen to it when I die. That is another way to avoid probate. I had someone ask recently the difference between a ladybird deed or enhanced life estate deed and using a trust. And they're completely different tools. we would use for different purposes. But one thing that the trust would let you do is control from the grave. You could have contingency planning. If Margaret were to die, it goes to Samantha. Or Margaret can live in it for her lifetime, but then when she dies, it goes to my children. You can have a lot more flexibility with the trust about what you want to happen with your property than you can with an enhanced life estate deed. Next two slides are just some examples, and then I'm going to close it down and open it up just for questions. I don't see any in the chat yet. All right, so this is a non-trust probate avoidance example. So John owns a house. He has a checking and savings account, a brokerage account, and an IRA, 401k, a couple retirement accounts, and life insurance. So potentially, after consultation about what he wants to accomplish and who his beneficiaries are, we could potentially do a ladybird deed for the house. That transfers that without probate. We can do pay on death for his checking and savings, transfer on death for his brokerage account, and beneficiary designations for his retirement and life insurance. When you think about this scenario, remember what I said a couple slides ago, that this probably isn't going to work if there's more complexity to his planning. If he has minor children, special needs children, he's in a blended family, he owns a business, has a non-US citizen spouse, those kinds of things would make this scenario most likely not work for John. But we're assuming that everything is all going to one or two people and he doesn't have any need to control from the grave. If that's the case, then this is typically a plan that could work. We had a question on the ladybird deed, so let me do that. So if it's a ladybird deed, not a trust. So and I just want to make that clear, it's not a trust. A ladybird deed, so it's a type of deed that we file with the county clerk that replaces your current deed to your real estate. If my daughter marries, does her spouse own half when I die? No. When you die, your daughter owns 100% of that property. Okay. Now I'm going to go on to the next slide, which is a trust probate avoidance example. Remember my bucket analogy. So Sarah owns a house in Florida, a condo in North Carolina, and again, she has the same things, John, the checking, savings, investments, and life insurance and retirement. So for her, she has that house in North Carolina. So I have to have a way to avoid probate for her because that's what she wants. She wants a plan to avoid probate. So if we create her bucket, we can have a North Carolina attorney deed that property into her bucket. Here we deed her property into her bucket in Florida. And then she retitles her brokerage accounts and her checking and savings potentially into the trust. And then she might make the trust the beneficiary of her retirement and life insurance. It really just depends on what her goals are. And we talk through the scenarios there. Sometimes you do make the trust the beneficiary, sometimes you don't, just depending on, again, the complexity of your situation and what you're trying to solve. Another reason why she might want to trust in this particular situation is maybe she has minor kids and she doesn't want them to inherit, $1 million or whatever when they're 18. She wants to be able to, again, control from the grave and determine when her kids get what and what incentives she might want to put in the trust, like, they have to graduate college or they can't be in jail, things like that. So a trust gives you a lot more options on what you want to do with your plan than a ladybird deed does. All right, so I'm going to leave that up just for a second in case you don't have our contact information, but I think you all do because you all must have gotten the email. So I'm going to stop sharing here and I'm going to open it up just for questions. What would be best for incapacity clause? Peggy, I'm not sure what you mean by that. I can tell you that trusts are the best tool for incapacity planning because, again, you have that bucket, and if you become incapacitated, whoever you've designated to be in charge of your bucket, if you're incapacitated, now can step into your shoes, essentially, and use your assets for your benefit. Whereas if you don't have a trust, then we have what's called a power of attorney. You would have that anyway, even if you did have a trust. But if you don't have a trust, your power of attorney has to go to every institution with that power of attorney. It's just a little bit more work on their part. Um, Both documents, or let me back up. If you have a trust, you're going to have a power of attorney anyway. If I do your plan, but if you have a power of attorney, you might not have or need a trust for your incapacity planning. Not sure if that answered your question, Peggy. So please feel free to type some more, or you can feel free to. You don't have to come off video if you don't want to show your face, but if you want to just come off and have a conversation about it, I want to make sure that I've answered your question. So essentially what we've done is I've talked to you about what probate is, and I've talked about the main two ways. There are a few more, but the main two ways we probate in Florida. We have the formal and we have the summary. What we really want to do, though, is try to figure out a way to avoid it if we can. Some clients, they don't care. They're like, I'm going to be dead. I don't care. It's somebody else's problem, and they don't mind that it's eventually going to need to be probated. I would say the vast majority of my clients do care. They don't want it to be their spouse's problem, their children's problem, or anything like that. They also are worried about other things like pet care, for example, or they might have charities that they want to make sure that they take care of. Some of my clients have chosen families, and they are really no longer a part of their biological family. And so without a plan in place, you saw that the chart, right? What Florida says. So if you don't have a plan, everything is going to go to family that you may not even still be talking to. All right, I think we have some questions here. I own timeshares jointly with one relative and another with a close friend. They both have an expiration date, but with nothing on paper about beneficiaries. Does this cause a probate situation if not expired yet? Pat, that really depends on the language in your timeshare agreement. There are different ways that they word that. If it's what we call a term timeshare, they probably have other ways that gets essentially forfeited if you pass. But you really have to look at the language in the timeshare for sure. All right, Penny says, if I have all major assets set up as your example with Ladybird deed, pay on death, TOD, what happens with just stuff in the house? Can my brother just come in and take or sell clothes, furnitures, etc.? Yeah, so in Florida, typically, you're looking at those being exempt assets, so they are not probated assets. So yeah, we generally don't probate for just our personal property unless you're owning the Mona Lisa or some Picasso or something like that. Potentially collector cars would have to be probated. But if you're just talking about, your weekly Target haul that you bring home, we generally aren't worried about doing probate for that. So yes, to answer your question, Penny. Let's take a drink. So if I had, and I'm not making this a commercial for myself at all, but my strong recommendation is to have complimentary consultation with the estate planner of your choice to make sure that you've talked through all scenarios. I get a lot of clients that come to me and they've started the conversation with my assistant with, I have a really simple estate. I really don't have anything complex so I just want a simple plan. But when we actually get in to talk about it, what they want to have happen is not simple. So having these conversations is important with someone that can help you talk through all the scenarios. Peggy, they're just given. They're not handled. They're just given. It really depends on your will control your exempt assets. So let's say my will says that my baseball card collection goes to Tracy. Well, my personal representative would make that happen, but we don't have to probate that to make it happen. Pat, no, I don't have an office in Bradenton. I closed that about four years ago or so, right after COVID. But I do see clients virtually all over the state, so I offer Zoom appointments if you don't want to make the field trip to St. Pete. So Peggy, that's a good thing to bring up though, is that's like, even if you have your TODs, your PODs and all of that, you still want to have a will. A will does a couple of different things. It says what happens to your exempt property, so your clothes, your furnishings, your car. It says who your personal representative is in the event we have to deal with the IRS or Social Security or Medicare or something like that after you die. It's your personal representative that has that authority. Additionally, if you were to die through someone else's negligence, let's say a doctor's negligence or someone driving a car and kills you, it's your executor who has authority to sue on your estate's behalf to collect any benefits. So it's still important to have a will, even if you're avoiding probate with your non-exempt assets. All right. I'm going to hang out here. That concludes the formal presentation, but I want to make sure if you have questions, you've had an opportunity to ask them. So I'm going to hang out for a minute, but if you are satisfied you've gotten everything you wanted to get done, please go enjoy the rest of your afternoon. Oh, here's another question. If we already have a trust in place, could you assist with putting a home into the trust? As long as the home is in Florida, yes, we can help you fund the trust with the property. Usually, if it's a married person, what I'll do is do a ladybird deed to trust. So you and your spouse continue to own it as tenants by the entirety, but in the event you both pass, it would automatically fund to your trust. But depending on what you want to do with the house, that may or may not be the best thing to do. So if a property owner has a ladybird deed and the owner passes away and the property has a mortgage on it, does the mortgage have to be refinanced by the new owner? Yeah, they're going to have to refinance or pay off the note. The house will come with the lien on it for sure. They don't get it free and clear. Would you put your child on an auto title? Absolutely, 100% not. In Florida, we have what's called the dangerous instrumentality doctrine. That means, whoever owns the car, whether they're driving it or not, can get sued for any accidents. I wouldn't know, Peggy, what the benefit of putting a child on the car would be for either you or the child. There is a way at the DMV, and I know no one wants to go to the DMV, but you can do a transfer on death of your vehicle title as well. But Peggy, I have to talk to you about what you were trying to accomplish, but I can't think of a scenario off the top of my head where I would think that would be a good idea. What else you got? These are some good questions. Good discussion fodder. One thing I want to make sure is when people do things and they think that they're going to avoid probate, that you make sure that you know what you're doing. For example, I had clients came to me after one of them passed. They owned multiple rental properties. That was their business all across Tampa, St. Pete. I think there was a total of maybe 15, and both their names were on the title. They weren't married. One of them had an estranged daughter that neither of them spoke to. The mother of the daughter dies, and it wasn't not until then, when the survivor came to me, that they realized that they owned all of these properties as tenants in common instead of joint tenants with rights of survivorship. And what that means is 50% of every piece of property that they owned went to the estranged daughter. So bad things can happen sometimes if we don't talk to someone that has experience in making sure that what we're trying to do is actually what we're doing. If I own my car free and clear, is it considered stuff in house, or do I need to specify a will? It's considered your tangible personal property, Carol. So the only time I have people kind of split that out is if they specifically want someone. So I've had clients that specifically want their grandson to have their Jeep or something like that. Otherwise, it just gets, if you're giving everything to one person, that includes the car. If you're giving everything split between your kids, it means the kids can sell the car and split the money, or they can agree that one kid gets the car. Hopefully that answered your question, Carol. If not, yell at me. Okay. If you are interested in coming to have a conversation with me about your specific thing, you can email Vicki. She's on here. She'll put her email in the chat, and she'd be happy to set that up for you. Again, you can do in person, or we can do a Zoom as well, just like this. Well, just like this, but without the 20 other people involved. So just be you and me. The next lunch with Liz in June is a special Pride lunch with Liz. It's about serving our LGBT community and the specific things that we may need to do to protect ourselves in Florida regarding our estate planning and ensuring that our wishes are followed. Both, when you think about estate planning, it's really two parts. It's one part is what happens to my stuff when I die, and we've talked about that a little bit here today. But the other part, what I consider more important, is what happens if I'm alive, but I can't make decisions for myself. I can't make medical decisions. I can't make financial decisions. Who is going to do that for me? So making sure those documentations are in place to ensure that your chosen people are making the decisions and not someone that the court decides. Should you have a list of things in your paperwork for your executor to distribute them? Is your person legally bound to do that? Well, it depends on what your documentation says. In my trust and in my will, it always says I may leave a separate writing, and if I do, my personal representative is required to follow my wishes. So yes, if you leave a separate writing and you have referred to it in your trust or will, your executor, your personal representative is bound to follow your wishes. The important thing for that, Pat, is to make sure that the list is where your executor can find it. So my recommendation is you keep it with the will or the trust. Penny says, I'm a Florida legal resident, homestead, and I also own a small summer home in Minnesota. Do I need an entire Minnesota estate plan for that? Well, that's going to depend. I don't know. Minnesota might have a transfer on death deed, something similar to a ladybird deed, so you might be able to deal with your property that way. I don't know if they do or not, to be honest with you. If not, you would be doing either a trust-based plan in Florida, where we can fund that Minnesota house into the trust, or potentially you would just have to do, your family would have to do a probate in Minnesota, or whoever you're leaving the Minnesota house to. They would have to open a probate in Minnesota. So that's Penny. It depends, and I would need to talk more about what you're trying to accomplish, how it's owned, that sort of thing. Does married couple as tenants by the entirety automatically go to the surviving spouse? Yes, it does, Laura. Absolutely. Even if it doesn't say tenants by the entirety on your deed, if you all are going to go and check your deeds now, as long as it says a married couple or husband and wife, and really there's some case law that says as long as you were married at the time that you purchased it, even if it just said the two people, it's considered tenants by the entirety. But it's better if it has husband and wife, or husband and husband, or whatever it is to trigger that tenants by the entirety. And the reason tenants by the entirety is great is because there's bankruptcy and homestead protections that TBE designation has. Okay. I have an existing trust that was created in Massachusetts. I now own a home in Maine, and my Florida home is primary homestead residence. Do I need to revise the entire trust? Yeah, I don't know the answer to that. You would need someone to review the trust and what the intention behind it was. Typically, I would say no, but it's the famous lawyer answer, it depends. Safely, I would say, have it reviewed and get some advice on it. I wouldn't think that the whole trust would need to be revised, but I don't know the answer to that. Next question. What is the list mentioned above for executor actually called? It's not called a letter of instruction, although I don't think any court is going to be caught up in the name of it. It's called a separate writing or a personal property distribution form. But again, as long as it's a piece of paper, it lists what you want and who to give it to, and it's signed and dated by you, your executor is bound to follow it if that's the designation you have in your documents. Okay. Well, we're about 10 till. I am going to close the Zoom. Have a great day. Tell your friends about next month's special LGBT lunch with Liz. We're going to be taking July off. And then August, we'll be back with a special guest talking. Um, and I forget what she's talking about, but we have a special guest in August. So stay tuned about those. We'll get those flyers out about the upcoming Lunch with Liz at the end of 2026. So I appreciate y'all coming, and hopefully we'll see you next month.